Oyez, oyez, oyez. Anyone have business for the King's Justice of the Superior Court of Justice, the 10 now shall be heard. Long live the King, the Honorable Justice and the Seat presiding. You may be seated.
Good morning, all.
Morning.
Morning, Your Honor.
Good morning.
Morning, Dr. Von Gurnett.
Good morning.
I believe when we broke yesterday afternoon, we were at slide 127. May I ask you to pull that up again?
Sorry, what number?
127.
127. Thank you.
Now, this, of course, is chapter 6, and we were having a discussion about what you entitle in this chapter the unfinished business. And you had described previously award number 3, and then some work that Boren, who was a magistrate now, you told us, no longer an MP, had been doing, and communication that he had with Emilius Irving, Ontario's counsel. Did we finish slide 127, Dr. Von Gurnett, from your viewpoint, or was there anything that you wish to do, take the court's attention to on that slide?
Well, slide 127 is the additional reason why this whole issue of entitlement became a problem for Boron. Because as you recall, prior to the 1850 treaties, the annuity provisions were these annual fixed payments. And so the Crown's liability was also fixed at 26,620. And so the Robinson annuities were dealt with in the same way, but only in the sense that the pre-augmented amount, which was 4,400, was drawn annually from the CRF. And the individual, if you did the math, there'd be variation as to what the individual shares were. So under such a system, the entitlement is not really an issue. So as I said before we broke yesterday, Robinson had left this whole issue of entitlement to the chiefs. In practice, of course, the original pay lists became the model for who would or who would not be paid later. But then what complicated things were statutory definitions of Indians, and of course the arbitrators themselves had also introduced rules that would influence who was and who was not entitled. And so now what you have is an open-ended system instead of a single fixed annuity that was predictable. You now had a total amount that was less predictable because it was subject to entitlement issues.
And when you say that the arbitrators had made a determination about that, you're referring to what you told us yesterday in award number 3?
Yes.
Could I just ask, sir, when you use the word entitlement issues, are you talking about the fact that there were debates about who was entitled, or just that the number of people being paid was open?
Both.
or sorry, the number of people being paid was a number in the calculation.
Yeah, so remember that because Laird's model was used,
Mhm.
the time of treaty population was irrelevant, and it was now done on a yearly basis,
Current population.
current population. But the current population was determined not only by the pay lists, but also by whatever rules and regulations of statutory provisions there were that allowed an individual to be either an Indian or a member of a band.
So I was just trying to figure out what you were saying was when the calculation was made as per, I'm not sure whose version we're calling it. The 1875 definition, it would be $4 per capita.
Yes.
When those calculations were made on an annual basis, was the Crown doing anything other than looking at the pay lists? Were they entertaining these debates about who was entitled?
Well, the pay lists were the document that first and foremost was the one that determined entitlement.
Yes.
The pay list from the previous year. However, once you had the introduction of statutory regulations, like for example, the 1869 statute, which defined Indians in a rather restricted way. Remember, I talked about at the beginning of my testimony, there was a discriminatory provision in there that wherein women were.
We're all aware. Yep.
Yes, and that then became part of the Consolidated Indian Act of 1876. So all of this created problems across all treaties. It's not just Robinson, right? Now, in addition to that, Boron had in front of him an arbitrator's decision, which also referred to entitlement. And he thought it was.
I was just asking if your comment about payments, about making the calculation, was affected by these issues. It was my impression, I thought, that those issues were being fought or determined in other forum, but on an annual basis. Are you saying that these issues were being determined?
I have not looked into what effects the actual statutory regime changes had on the Robinson Huron and Robinson Superior Treaty pay lists. But what I am aware of is Boron's concerns that applying what he referred to as a liberal approach to this would result in the addition of numerous individuals that Boron deemed to be not eligible, and hence Ontario's liability would increase over time as a consequence of what he thought was a rather arbitrary expansion of the entitled individuals.
Okay, thank you.
And when you say Ontario's liability, you're referring to the decision that you took us to yesterday
Yes,
of the arbitrators.
that's the only thing he was talking about.
Can we look at slide 128 then? What are you telling us about here?
So in slide 128,
Perhaps you've covered it in part in response to Her Honor's question.
yeah, so now recall that layered system that was adopted That was in 1874, and it would then be applied to the first annuity in 1875.
The first augmented annuity?
Yes, the first augmented annuity. And since Laird's system was based on the annual population numbers, the liability, as Boron understood, it became open-ended. And that's why this whole issue of entitlement was enlivened. And one has to think of the chronology here as well. Laird's system was adopted at the very time that you already had 3 of the numbered treaties, if not the 4th as well. The 4th was in 1874. So you had these numbered treaties now extant, and these numbered treaties all had a provision by which every entitled person would receive $5. And so this then was a means by which the Robinson treaties tended to resemble more the current numbered treaties rather than the older pre-1850 treaties. Because again, time of treaty population is not relevant. It's now just simply whoever is entitled.
You mean starting with Robinson?
Yeah, so starting with Laird's system applied to the Robinson augmentations. So every entitled person was given $4, which meant that entitlement mattered. Just like in the number treaties, every person was given $5. Entitlement mattered. In the pre-1850 treaties, entitlement didn't matter.
And then you continue with Boron on slide 126.
So Boron then says, he thought that Robinson's original intention had been to follow the earlier treaties in which the Crown had incurred a limited liability. As I said, it was the 26,000 and that was it. So the only obligation under Robinson would have been the 4,400, just like the 26,620.
Sorry, are we at slide 129?
Yes.
Yes, I'm sorry, I misspoke, 129.
Thanks. Go ahead.
Yeah, so I just wanted to quote from Boron. But in order, as Mr. Robinson says, to leave the Indians no just cause of complaint, a clause was inserted securing to them certain prospective advantages. The insertion of this clause marked, as I believe, a new and dangerous departure from the policy pursued by the government in previous treaties. Under that clause, as soon as it came into operation, the pecuniary obligations of the Crown or province thereafter became vague and indefinite. For although no Indian could claim more than $4 in any one year, no limit whatever was placed to the number of individuals who might, in the course of time, become entitled to that amount of annuity. So for Boron, this quote unquote new and dangerous departure from the previous policy was not that the augmentation was linked to net proceeds. He really had nothing to say about that whatsoever. But that there was no specified upper limit on the number of annuitants.
Can you remind me, and I'm sorry to ask, this quote is from what? A letter from Boron to?
So this is Boron as magistrate for this entire region up north was asked by Council for Ontario, Emilius Irving, to provide an opinion on the arbitration award. And this is Boron's opinion in response to,
And it's going to,
Emilius Irving, who is counsel for Ontario before the arbitration.
thank you. And it's post the arbitration because it's an opinion on the award.
That's correct. And as I said yesterday, Boron had no problem with the portion of the award that placed upon Ontario a liability. But he did have concerns about the arbitrators, rather what he called liberal view of entitlement.
And then I think you rather sum that up at the next slide, 130.
Yes.
Can we look at that one then?
And Boron, he'd been an MP for many years, and he was a real northerner. He was spent most of his life up in this northern region, and he had dealt with Anishinaabe peoples for a long time. And he also understood the wider implications. And so he added, quote, as regards all those Indian tribes or bands whose annuities consists of sums payable to each individual, the definition of who are Indians entitled to claim the annuities so paid is a matter of very great importance to the Dominion, as well as the provinces of Ontario and Quebec. So here he's alluding to these other treaties, and those are the number treaties.
And remind us what number were we up to at that point in time?
Well, this is now 18, when is this here?
The award was 1895, you've told us.
Yeah, 1895. Okay, so treaties 1 and 2 were in 1871 and 72. Treaty 3 was in 1873. Treaty 4, 1875. Treaty 5, 1870. Treaty 5, 1875. Treaty 6, 1876. 7 was in 1877. And we had not yet had Treaty 8, which was in 1899, I believe.
Thank you.
So the first 7 is the answer.
Quite a few, okay. Then you've got an issue here about entitlement again at the second bullet point. Can you talk to us about that one, please?
So this business of the entitlements eventually came before the Board of Arbitration. And finally, in 1898, there were guidelines issued. So overall, the problem really was that you've got all these different definitions of Indian. You had definitions that arbitrators had, which were not necessarily in accord with the statutory definitions. Canada, in fact, anticipated great difficulty in finally settling the accounts.
And on what basis do you say that?
Well, because eventually Canadian officials recommended settling rather than further litigation.
And then I think we changed topics slightly, still within the aftermath of the unfinished business. At slide 131, you go back to discussing what happened with award number 3 that you discussed yesterday.
Yes.
Can we talk about that next, please?
Yeah, so for obvious reasons, Ontario appealed to the Supreme Court of Canada. That section of the award that made the province solely liable or solely responsible for the payment of the post-Confederation augmentations. So Ontario, as it had all along, claimed that there was no trust or any kind of retained interest in respect to the treaty lands. And the Council for Ontario, and I'm quoting here, said, quote, "It would have absolutely defeated what the province of Canada was desirous of carrying out. For what the province of Canada wanted to do was at once either absolutely to give away or absolutely to sell or absolutely to deal with these lands," end quote. And then,
Sorry, and
Sure.
I'll just ask, this is, when Ontario makes this claim, they're framing this as at time of Confederation?
no, this was at the
It-
time of,
Or what the province?
I notice it
Yes.
references the province of
yes,
Canada.
it's what the province of, the United Province of Canada would have understood at the time of treaty.
Sorry, so clarify, what the province of Canada wanted to do was at once post-treaty? Is that what that means, at once?
By virtue of the treaty.
By virtue of the treaty,
Yes.
be able to sell, give away, or deal with the
Yes.
land? Thank you.
So Canada argued that prior to Confederation, Canada would have had to pay the debt out of the proceeds of the land. And that the same thing should hold for Ontario after Confederation. And according to Canada, quote, "Ontario has got the fund out of which is to come the proceeds or funds which have to pay the annuities. The payment of the annuities is conditional on the person holding the lands enabling the payment of those increased annuities." So you can see the difference between the two positions at this point.
And what do you know, or what have you told us about how these were paid at that point?
Well, of course, up until that point, they'd always been paid out of the CRF. So what Canada was suggesting did not actually happen and was not happening at the time.
So these are the positions you've told us that was taken on appeal. And could you tell us where the appeal was taken to?
Well, this went to the Supreme Court of Canada. And
on slide 132,
yes.
you have a summary here.
So the Supreme Court of Canada, the Chief Justice Strong wrote the majority opinion, and he thought that this was in large part a question of how the augmentation clause was properly read. And so this is just a section. I'll just read it quickly. The quote: "In the first place, nothing in the clause of the treaties providing for the augmentation of the annuities in the event specified indicates that the undertaking to make these increased payments was to constitute them a charge or lien upon the surrendered lands. There's nothing showing that either the original annuities of £600 and £500 per annum or $1.60 per head of the respective bands of Indians were to be paid out of the proceeds of the lands or out of any particular fund. nor that in the event of a right to the increased amount arising, it should be paid out of any particular fund. All that is specified is that in the event of the augmentations being payable without loss, they were to be paid. This does not mean that the increase was to be paid out of the proceeds of the lands, but has reference only to the event in which the increase was to become payable. There is therefore no ground for saying that there was any express charge, lien, or trust. So in essence, this kind of reflects what, that debate between Blake and Mowat going back to the 1873, 74, 75 period. It was always Ontario's position that, the annuities need not come from the proceeds of the lands. The augmentation clause was there only to provide the threshold under which augmentations would be paid. It provided the conditions.
And I think you've moved on to slide 133 here.
Yeah, so as I said, this is consistent with the actions of Crown actors, at least those who for the last 44 years had never paid either the pre-augmented or augmented annuities from the proceeds of the lands. And as I just said, it's also consistent with Ontario's position that its only obligation was to provide information, allowing Canada to determine whether the condition of the augmentation clause had been met.
And when you say it is consistent, you're saying the decision of Chief Justice Strong.
Yes.
Thank you.
No, among other things, Strong also recommended, or I should say, it was of the view that the arbitrators who had issued that 1870 award, you may recall I made a brief allusion to it earlier in my testimony, on the understanding that there are other experts who will deal with this as well. In that September 1870 award, a decision had been made, and Strong was of the view that,
Here we call him Chief Justice Strong.
I'm sorry, Chief Justice Strong was of the view that this had already been decided as a matter of law. Obviously, I don't know one way or the other. I'm just repeating or summarizing what views he held. And I want to emphasize that I have no legal opinions on any of this one way or the other. I'm only here as an ethnohistorian trying to figure out what was the thinking in the 19th century of these men, and they were all men at the time.
I'm just possibly confused about this. You say that Chief Justice Strong was of the view that this had already been decided as a matter of law. Is this not Ontario's liability? And isn't Chief Justice Strong's decision contrary to the Board of Arbitration?
No,
Am I confused about something?
well, the September award,
The September 1870 award?
yeah, September 1870 award had decided that the Robinson territories were the absolute property of Ontario, and that the annuities were not charged upon the surrendered lands, and that there was no trust or purpose for that purpose of paying the annuities.
Okay,
And Chief Justice Strong, I don't pretend to understand the wording of the September 1870 award, but I'm just saying that Chief Justice Strong was of the view that that award had already decided a matter of law.
thank you.
And then you conclude this slide with discussing what the majority of the Supreme Court did. And I understand, of course, that that is Chief Justice Strong's decision. Can you take us through that last bullet?
So the majority of the SCC, it was a split decision, allowed Ontario's appeal and ruling that the province was not solely liable for repayment to the Dominion of the increased annuities. And it was only liable jointly with Quebec as representing the old province of Canada. And so at the end of the day, the Supreme Court of Canada varied paragraph 6 of award number 3 so that it now read, and in fact replaced it, and so that it now read, quote, the ceded territory mentioned became the property of Ontario under the 109th section of the British North America Act 1867, absolutely and free from any trust, charge, or lien in respect of any of the annuities, as well those presently payable as those deferred and agreed to be paid in augmentation of the original annuities upon the condition in the treaties mentioned, end quote.
I'm so sorry to bring this up, but it's my confusion. You say Chief Justice Strong was writing for the majority, that his decision was consistent with Ontario's position, that Ontario received the lands absolutely with no trust upon them. But are you saying that is consistent with the September 1870 award? But I thought this was Ontario's appeal and Ontario was.
But this is an appeal of award number 3, Your Honor,
So September 1870 is,
a previous arbitration award.
can we give it a number?
It well,
It's just the 1870 award.
Not
it's
award
referred,
number 3.
it's referred to in our materials and my opening statement as the September 1870 award. For whatever reason, they don't seem to have numbered it.
But it's not award number 3.
No,
Got it. Thank you. And the Supreme Court decision is with respect to award number 3.
yes. But they referenced the earlier 1870 award
Right.
on a specific matter of law.
Does that help, Your Honor? Should
It
we-
does. Thank you.
And if you can take us through slide 134, Dr. Von Grenett, I believe you're discussing here some of the comments of the other justices of the Supreme Court.
Yeah, so Justice Taschereau concurred with Chief Justice Strong without further comment. And Justice Sedgwick joined with Chief Justice Strong and Justice Taschereau in the result, but he wrote his own reasons, which were consistent with Chief Justice Strong's, but provided a more detailed rationale. And for Justice Sedgwick, the Crown had an obligation to pay the augmentations, but the Anishinaabe did not have a right to the proceeds from the lands, no matter what they amounted to. He concluded that the Anishinaabe did not have a charge upon or interest in the lands that they had ceded, and that the lands or their proceeds were not subject to any interest or trust, and that the lands have become the absolute property of Ontario. So again, that's my summary of it. I would encourage Your Honor to read the decision for yourself. Obviously, you're better positioned to to make sense of it.
Then you did mention, of course, that it was a split decision.
Yes. So there were 2 dissenting voices. There's Justice Gwynne and Justice King. And I'm those views are reiterated at pages 394 to 396 of my report. Again, I don't think it's necessary to go through them.
Was the Supreme Court's decision the final word on the matter?
No. In those days, as you know, Your Honor, the Supreme Court of Canada decision could be appealed to the Judicial Committee of the Privy Council, which was in England. And that's indeed what happened. Canada appealed, and in 1896, the JCPC, Judicial Committee of the Privy Council, unanimously affirmed the SACC decision. And again, I just quote this particular section.
Can you take us through this?
So this is now a quote from the Privy Council decision. Their lordships are of the opinion that the language of the treaties in question does not warrant the conclusion that payment of the original annuities and other augmentations was to be derived from different sources, as the learned arbitrators appear to have held. The promise and agreement upon which the obligation for the payment rests is, in both cases, expressed in precisely the same terms. Their lordships entirely agree with the following observations by Mr. Justice King, one of the minority in the Supreme Court. So now they're quoting from Mr. Justice King. Practically, it does not now, and it never did, make any difference to the Indians, whether they were declared to have an interest in the proceeds of the land or not. Their assurance would be equal in either case, end quote. And then the JCPC opinion continues, quote, even at the present time, and in view of the change of circumstances introduced by the Act of 1867, their lordships think it must still be matter of absolute indifference to the Indians, whether they have to look for payment to the Dominion, to which the administration and control of their affairs is entrusted by Section 9124 of the Act of 1867, or to the province of Ontario.
And I believe the next slide continues about the JCPC.
Yes, and that particular well, the JCPC could not understand how, quote, a liberal construction should be resorted to for the purpose of raising an equitable right in the Indians, which is of no pecuniary advantage to them, and to which Ontario had never consented. Further, quote, their lordships have had no difficulty in coming to the conclusion that, under the treaties, the Indians obtain no right to their annuities, whether original or augmented, beyond a promise and agreement, which was nothing more than a personal obligation by its governor as representing the old province, that the latter should pay the annuities as and when they became due, that the Indians obtained no right which gave them any interest in the territory which they surrendered other than that of the province, and that no duty was imposed upon the province, whether in the nature of a trust obligation or otherwise, to apply the revenue derived from the surrendered lands in payment of the annuities, end quote.
Okay. So of course, you've told us that the JCPC, the Judicial Committee of the Privy Council, is the highest court. Did this end the matter?
Well, it did. It ended some of the matters, but there were still outstanding issues, and so the long history continued.
What was still ongoing?
Well, all the legal decisions did is sort of to frame the 1898 and 1900 arbitral decisions.
These are more arbitral decisions.
Yes, there are more arbitration decisions. So this was sort of a legal step before, so I guess sort of stage one, which would then result in framing stage two for the arbitrators, if you will.
And I take it that at slide 137, you go through some of these?
Yes. So then on January 7th, 1898, the arbitrators issued award number 10. And this was on a disputed question of law regarding the meaning of certain words like debt and liabilities. I don't profess to know, everything that they were talking about, because there's some arcane legal arguments and debates about that. But at the end of the day, they determined that, quote, the contingent obligation devolving upon the Dominion of Canada to pay the increased annuities, end quote, under the Robinson treaties, and the augmented annuities which had become due since Confederation up to and including the last day of 1892, quote, shall be taken into account and included in the debts of the former province of Canada as per section 112 of the PNA Act. So then Quebec appealed the award, number 10, to the SCC. And in October 1898, the SCC decided that the arbitrators had it right and their award should stand.
Do you know if that decision was further appealed to the Judicial Committee of the Privy Council?
Yeah, I don't recall that offhand.
And then you mentioned award number 11.
Yes. So award number 11, which was on January 7th, 1898, the arbitrators issued guidelines respecting who was and who was not entitled to RST and RHT annuities. And it also gave an order listing the classes of expenditures to be considered in determining if augmentation of annuities could be paid without incurring loss. So, I mean, it seems incredible to us today, perhaps, but these were still live issues in 1898. So, when I said yesterday that this was not a simple matter, it was rather complicated. I think this is another demonstration of that. They're still debating this and requiring arbitration on the matter this late in the 19th century.
And then while this was
Can-
going on.
Sorry, Ms. Barker, can I just ask you a question? It's,
I'm sorry, me?
yes, because it's just, for whatever reason, I'm becoming very confounded by the language. If you go to bullet number 2
On
So
which
this is the-
slide, Your Honor?
on 137. So it's the award number 10
Yes,
and the part in quotations at the end shall be taken into account and included in the debt of the former province of Canada.
yes.
So are they saying that all annuities paid up to the end of 1892 are a debt owed by the Dominion to the province of Canada? Or sorry, between Confederation and up to 1892?
I can certainly give you my opinion, but I'm being careful. I might commend you to Ontario's opening statement, which discussed these. There may be some information that you may get there.
Okay,
This is a live issue between my friends Canada and Ontario, so I'm hesitant.
just the interpretation of those words is,
The interpretation
fact.
of those words,
I have,
I would
both
s-
Canada and
yeah.
the plaintiff seem to be ready to
jump up as
either,
well. I can't see what's
either
going on
make it
behind you.
make it muddier or make it clearer.
I mean, of
If,
course, if I might just answer the question posed to me, as I understand it, of course, you've seen 111
Yes.
said that the existing debts and liabilities existing at the union are Canada's. And then there's this issue of debt in excess of $62.5 million is to be figured out what that is. In fact, as Dr. Von Garnet told us, Mr. Langton was doing.
Right.
And divided between Ontario and
And-
Quebec, and that's where the arbitrators come into play. So I think that's what they're talking about here, that those amounts of money shift over into 112 to the extent that they are above the excess
62.
debt set by statute, which of course gets a little bit more complicated, as you heard from both Ms. Evans and myself in our opening statements. It was increased at one point
Yes.
in time. And I
Okay,
understand my friends.
who's first?
oh, I'll go first, I'm up. The question you ask is a fair one. If Ontario has to take a position, it can't sit on the fence on this one and not answer your question. As between Canada and Ontario, and it may affect my clients. Either the answer to your question is yes, or it's no. Ontario has to take a position. They can't prevaricate and say, well, it's what the documents say, because we're here to sort out a dispute between between the parties, and it's not fair to sit on the fence on that question.
All right. Maybe my question wasn't fair, but go ahead, Ms. Evans.
Well, I think
Do you have a mic close by?
Ms. Evans, the mic just needs to be
Just,
I think there is a simple answer to your question, Justice Hennessy, which is an interpretation of this quote here. You might recall that if the annuities were a debt of the province of Canada, then
or a debt of. I'm just worried that I'm not understanding how the word debt is used.
well,
A credit, are you saying a credit to the province of Ontario? Yeah, sure. Thank you.
I'm sorry, but what the arbitrators were finding here was that this was not, that the liability to pay the annuities did not rest with the province of Ontario alone. And I think my friend would agree with that.
Okay,
That's what the arbitrators were finding. It did not rest with Ontario alone. Instead, it was a debt of the former province of Canada. And therefore it was to be split, shared between Ontario and Quebec. So the Dominion of Canada only gets into this because it assumed the debt of the province of Canada under Section 111. But remember, it gets under Section 112, which is cited here. It goes back and collects from Ontario and Quebec. So the arbitrators are here saying that it's not Ontario who's solely liable. It's Ontario and Quebec pursuant to Section 112. It's a debt of the former province of Canada, Ontario and Quebec. And I hope that helps set things straight. But as my friend Ms. Barkley has said, you'll have plenty of opportunity to hear more about this from the other experts and certainly an argument.
so it's a matter of some dispute what it means. It's not just that I don't understand.
I think you will be hearing more about it.
All right, thank you. Is that fair? I'll just leave that I was, on its face, it wasn't clear to me and there.
Well, I'm not sure it is a matter of dispute unless Ontario says that they have a different interpretation than what Canada just professed. I didn't think it was a matter of dispute, but if it is, you can decide
Okay,
it.
but I
Yeah.
don't need to determine whether or how it's a matter of dispute right now.
Just whether it is.
Well, it wasn't clear on its face to me, and there will be evidence on this matter, on what it means.
There will certainly be evidence and there will be argument about what it means.
Okay,
Of
let me just catch up with a note or two, if you don't mind.
course. Would it be helpful when you're taking your notes to see 111 and 112?
I don't want to get into it now,
Okay.
actually. Thank you. Very good. Please go ahead.
Lost a bit of track where we were. Had we finished 137 or were,
Y-
yes,
y-
I believe we
yes,
had, am I correct?
Yes, I have nothing further to say about awards 10 and 11 and dare not get into those weeds.
That's right. And I'd started to ask you a question of while these arbitrations and the legal proceedings were going on, what was happening on the ground, so to speak? Can you tell us about
Yeah,
that?
so while all this is going on, there were other Crown officials who were preoccupied with, once again, trying to do a fine grain analysis of arrears, the dates when augmentations were payable, the number of annuitants involved. Those are the three main issues.
And when you say Crown officials, which Crown are you referring to?
Okay, so these were officials who were requested by counsel for the parties before the arbitrations and legal proceedings, who wanted guidance on information that
Sure.
would be
Thank you.
germane to the arbitrations and legal proceedings they were involved in.
So, and can you
So
remind
for
us what-
example, Amelius Irving for Ontario, Council for Ontario, would ask for more data from or information that was within Ontario's control.
Can you suggest that there's correspondence going on here?
Yeah, so there's considerable correspondence, and I wasn't going to go into detail and review every scrap as I did earlier. But overall, this burst of correspondence during this period leaves the impression that the parties wanted some kind of resolution to this entire matter of responsibility for payment as soon as possible, and that there were compromises that needed to be reached. If the parties were to reach some kind of consensus on this, they really didn't want to leave it to the arbitrators or the courts to decide ultimately on some of these issues. And so they started a correspondence among themselves. It's sort of,
When you say want a resolution on these matters that you had just listed,
yes.
payment dates, all these
exactly.
things that required information.
That's right.
Okay.
Yeah. And so by the end of April of 1898, Ontario had prepared a new set of calculations of the net proceeds from the RST and RHT lands for the entire period 1850 to 1892 inclusive, as well as they prepared sort of tentative statements identifying the years when Ontario and Quebec might have become conjointly liable to pay the increased annuities. And the statements that Ontario put together were accompanied by a disclaimer that, quote, "The number of Indians assumed to be paid are in accordance with Dominion allegations of payments and are subject to proof that such Indians are entitled to the increases." So here again, you see, by adding the disclaimer, they're still saying that, we need proof that all of the individuals that we maybe agreed to who are entitled to increases are in fact so entitled. So putting the burden on Canada to demonstrate that the numbers match the numbers that would be actually entitled to annuities.
Sorry, you say putting the burden on Canada. Isn't it, can we talk about the Dominion or the province of Canada?
No,
And isn't it the Dominion who's wanting proof?
no, the Dominion. The Dominion has its own ideas of like Ontario has control over the numbers when it comes to the actual proceeds, right? But the Dominion is responsible for Indian affairs, and it has the pay lists, and it has the statutes relating to entitlement and so forth. So it's up to the Dominion to provide proof to Ontario that the individuals that they propose, the numbers that they propose to be included within the accounting are in fact legitimately entitled to receive those payments.
Why is I thought Ontario was just providing data on proceeds.
Yes, but they are trying to come to a consensus here on the total amount.
So Ontario just says to Canada, you do your own work on who's entitled,
Well, the
on numbers,
Yeah,
population number.
yes.
Okay.
All right, so then by March, if you turn to slide 139,
So this is coming forward a year in time?
yes. So in March of 1899, Canada, Ontario, and Quebec reached a joint agreement. So this is like an out-of-court agreement, respecting the statements of all collections, expenditures relating to the RHT and RST territories during that entire period from 1850 to 1892. As I said earlier, there was a flurry of correspondence, and the impression that I got, and I would suggest anyone gets from that correspondence, is that they're really trying to settle this without further litigation. And so they reach a joint agreement. And then shortly thereafter, there was another agreement reached respecting the number of years in which increased annuities were payable, as well as the number of entitled annuitants.
When you say the number of years, of course, the annuities had already been increased. What is that referring to?
So what they wanted to know is basically something similar to the Johnson accounting. Remember the Johnson accounting that I discussed, and I gave tables
Those three tables?
yesterday, the three tables I gave. Yeah, they wanted something along those lines, and in fact they came up with such a calculation. And so they decided, the parties agreed that the RST augmentations were payable in 1853, 1854, 1856, and then from 1872 to 1874.
So
And-
essentially here, they're talking about when augmentation might have been made earlier. Is that fair?
Yes,
So for the purpose of calculating arrears, they identified the years in which augmentation should have been paid at the rate of $4.
yes.
Okay.
So so obviously in 1875, they are receiving the $4. But remember this whole arrears business, Boron, Dawson, Blake, they had all merely assumed that for some years past, as it was often said, there were some arrears that might have been payable, but nobody really knew exactly what it was. So here in 1899, the three parties came together and agreed, having looked at the numbers, and they may be different from the ones that we looked at in yesterday with Johnson's account.
So this idea of identifying the years is not consistent with buying into the notion that once the threshold has been met, it's met forever.
That's correct. And we saw that. Remember yesterday I talked about the
Mhm.
peaks and valleys, right? It's like Laird, and I refer to Laird as being naive, right? Because it wasn't, I mean, the idea that somehow you reached a threshold and after that you could drop the red pen and it's black ink all the way, that's not the way it worked. So they identified precisely the years in which this would have happened. So those are the years, and for the RHT augmentations, they were payable in 1873,
Okay, yeah,
1874, and so forth. So Ontario and Quebec agreed to accept the statements of entitled and annuitants prepared by Canada. So remember, we had this conversation moments ago. Canada prepared a statement of the numbers of entitled annuitants, and Ontario and Quebec agreed to it. The three governments also reached an agreement on the amount that would be capitalized for the future, or the amount to be capitalized for the future. So these numbers, as you'll see in the penultimate bullet point, Ontario and Quebec, as representing the former province of Canada, were to pay $17,232 for the RST and $95,768 for the RHT in arrears up to the end of 1892, as well as a $205,000 capitalization amount, quote, in extinguishment thereafter, end quote, of any claim by Canada for further reimbursements relating to the Robinson treaties. So this was the agreement that was eventually reached by the three disputing parties.
And then you talk about orders in council being passed
Yes.
on slide 140.
Yeah, so each government passed an order in council that officially confirmed their province or dominions understanding of the joint agreement.
Is this an excerpt from one of them here?
Yeah, so the excerpt on page 1 or on slide 140 is the one that the provincial orders in council had the same wording, and they each passed their respective orders in council containing this passage.
Can you take us through this?
Yeah, so quote, that the capitalized sum of $205,000 be charged to the said province of Canada account as of the 31st day of December 1892, and be taken to extinguish forever thereafter the annual charge of $8,200 for and in respect of the annual claims of the Dominion on behalf of the said Indians for increased annuities under the said treaties, and that the provinces of Ontario and Quebec, as representing the late province of Canada, be from and after the 31st day of December 1892, relief from all liability and further payment in respect of the said increased annuities, which may be payable under the said Huron and Superior treaties, end quote.
And so then these you've said are orders in council. What
Yes.
happened next?
Well, the orders in council were then collected. There's 3 of them. There's the Dominions version, and then there's the 2 provinces. And on June 2nd, 1900, counsel for the parties advised the arbitration board that they had reached an agreement and that these orders in council had been passed by the respective jurisdictions, and asked the arbitration board to dispose of the matter once and for all. And so then that leads us to the August 1st, 1900 arbitration board award number 15.
And what does it do?
So I call attention to the 3rd paragraph of that award, which is the one that reflects the agreement. And it reads, quote, "With respect to the said treaties, there be entered and charged in the province of Canada account against the said province as represented by the provinces of Ontario and Quebec. And as of the 31st day of December, 1892, the sum of $205,000 in extinguishment forever thereafter of any claim by the Dominion of Canada on behalf of the said Indians for increased annuities under the said treaties," end quote.
Thank you. Now that brings us to the conclusion of chapter 6. And of course, we had a discussion yesterday about chapter 7. What I propose to do, in light of that discussion that we had with Your Honor outside of court yesterday, is to lead Dr. Von Gernert through portions of the slide and ask him to overview or to touch on those portions which Ontario doesn't believe have been brought up yet. I think that will streamline things, and that it will not, or rather that it will help to not be overly repetitive with what Your Honor has heard over the last few days. Is that sufficient? Is that?
Well, it suits me if it suits you.
Thank you.
I want you to get out what you need, and I am always grateful if it's not overly repetitive. And have you jumped in? I'm looking at the plaintiffs on anything you were particularly.
I have provided to my friend a solution to the issue that we had discussed. Perhaps we can excuse the witness for a moment and we can short circuit this.
I would actually, we have reached an agreement.
Mhm.
I suggested to my friend that perhaps it's something that I can do at the conclusion of the slides.
That's
Great.
Now, Dr. Von Gernert, in chapter 7 of your report, you told my colleague, Mr. Marcello, earlier this week that you summarize your previous chapters, you summarize some of those executive summaries, and then you do provide some opinions towards the end of chapter 7, which also, I understand, appear at the end of these slides. Those slides in particular, I think it's fair that you go through them because we've not heard all of your opinions. But can you tell us, please, and I'm at slide 142. My numbering is off. 142. What, in your view, your report is doing and has done?
Yeah, so
The question is, what is your report doing?
what is the purpose of your report? What do you believe you have presented to the court with this report?
Well, in accord with my mandate, I examined the aftermath of the Robinson treaties with the intention of illuminating the actions that were taken by the Crown actors to pay both the pre-augmented and augmented annuities, as well as the understandings and assumptions the Crown actors held in taking such actions. So my interest as an ethno-historian is not just to chronicle the detailed documentary history of the actions taken in respect to these payments of annuities, but also to try and get into the minds of these people to understand why they took the actions they did. Why do historical actors do what they do? Sometimes, there's a disconnect between what we think they should have done, or we think that they could have done, or so you have to, put yourself into the historical context of the era and try and figure out, well, why are they doing this as opposed to that? Well, it's because the historical context of the period is different than the historical context is today.
All right, you started talking about you do something as an ethno-historian.
Yes.
Then you could do something or that a historian has certain obligations. If the plaintiffs in this case were not Indigenous people,
Yes.
and for instance, a historian would be asked, and for instance, the Laird course proposal or the Johnson proposal or the Blake understanding were before a court. But they need an ethno-historian or a historian?
Well, I think they still need an ethno-historian because the subject matter deals extensively, if not exclusively, with the contact between natives and newcomers in this country.
But when I'm asking the question with respect to, you say you put yourself in the minds of Johnson or Blake or Laird as Crown actors.
Yes,
And that's been the bulk of what we've heard from most recently.
yes.
Would you need to be an ethno-historian, understand the Anishinaabe people to do that?
Well, my report is principally about Crown conduct.
Uh-huh.
And Crown conduct was informed not only by the history of and the historical context of treaty making, but also informed by the claims and petitions and memorials that they received from the Anishinaabe who had an interest in the Robinson treaties.
Right. But I'm hearing very little evidence from you when you look at the Johnson proposal or the Blake proposal or the Laird proposal of anything about the Anishinaabe involvement in that thinking.
Well, the evidence that I do give is in the form of the petitions which stimulated the Crown conduct, right? Those
Triggered,
petitions
yes.
triggered, them,
Okay.
right? Triggered the Crown conduct. And those, I mean, if I'm talking, if my report is, if this is a Crown conduct report, it's focused on what the Crown did and what they thought. Where the Anishinaabe side of the story comes in is the wording of their petitions and memorials, which either fortify, which had the potential to either fortify or disabuse the Crown of what the claims are all about.
Right, but
Right.
that was evidence in stage one. I didn't hear any of that evidence in stage two, or sorry, so far in the last 2 weeks. It's not a question that meant anything more than what it said right on first blush.
Yes,
Could a historian look at these actions and put themselves in the minds of, as you say, they must do, Laird and Johnson when they make their proposals? Because it was your very answer that triggered my question.
Mhm.
A historian must do this. So if the plaintiffs were someone else, if the plaintiffs were Ontario and Canada, are you, in the evidence that you have given, particularly in the last couple of days, are you looking at an Anishinaabe context? I mean, maybe I'm just going way too far. into
yeah,
what's about to
my
come, but-
project here and my mandate was not to, was limited to what did the Crown actors do? And what was their understanding that underlay their actions?
Okay,
Right. So to the extent that an Anishinaabe view is important, which I don't deny, it bears upon what the Crown understood their claims were. Right. It's the Crown's
Okay.
understanding of their claim. Right, because these are petitions and memorials that are presented as a claim, and that's their understanding.
okay,
So the Crown may be wrong in their understanding, or they may be right. But at the end of the day, the Crown acted in accord with the historical context of the era and their understanding of what the Anishinaabe were claiming. And that was reflected in the language of the petitions.
thank you.
We run slide 142. And I understand these slides seem to be organized in a slightly different way than the rest of your slides.
Yes, so what I did was I mean, these slides are based on chapter 7, and my chapter 7 is organized not merely as a chronological summary, which is what the rest of my report is organized as. Rather, it's arranged thematically under several heads. So it's not in that sense a line by line summary of the preceding 6 chapters, but rather a summary and conclusion under various themes, if you will, which are given headings.
And then the first heading, of course, is then, I'm still on slide 142, paying the pre-augmented annuities.
Yeah, and so, I mean, what I did in my report was to try and place these Robinson treaties in the wider historical context, because they're neither the first nor the last treaties. Prior to Robinson, you've got all of those pre-1850 treaties, and after Robinson, you've got the numbered treaties, and you need to look at this in the wider historical context.
And then the number of slides that follow under that heading, I don't see anything that we've not heard you say. So while it might be a bit disjointed to jump ahead, I might suggest that we move to slide 148. And perhaps you can take us through this slide, which is entitled The Crown's Understanding of the Augmentation Clause. I don't believe all of this might have been covered. Perhaps you can tell me if you think I'm wrong, or you can take us through it.
Well, there's just, one 48.
148.
Yes. So I have a section in my chapter 7 in which I discuss the Crown's understanding of the augmentation clause. And so we're talking here about the Crown actors who were mandated to pay the augmented annuities. Clearly, the Crown actors were aware of the augmentation clause found in the treaties. And of course, they acted in accordance with their understanding of it. They appreciated that in the event the conditions of the clause were met, the annuity commitment, which totaled 4,400, would increase and more monies would have to be added to the annuity funds. However, they believed the treaty set an upper limit for that increase. And so bullet 3, I think is an important conclusion here.
Can you take us through this?
It was understood that the ceiling of the augmented portion of the annuity could be no higher than an amount sufficient to increase the pre-augmented payments to the point where upon division into shares, every annuitant would receive a grand total of $4 in any given year.
And then you go on to talk about population, but we have heard quite a bit about that. I propose we turn the page to 149. I think when you're talking at 148 about the Crown's understanding, I think you're recapping
Yes.
where some of this comes from.
Yeah. So, you know, why do I come to the conclusion that this is sort of the prevailing understanding of the Crown? Well, in part, it's just by the examples. You see it again and again and again over time. And I give on slide 149 just a few examples, and I need not go through them again in detail because we already did so in previous days. But you know, recall Sprague in 1873. The only way his actions make sense is if he had that underlying assumption that I just outlined. The same with the federal MP Boron. The same with Canada's Minister of the Interior and Superintendent General of Indian Affairs, David Laird. The same for the Deputy Superintendent General of Indian Affairs. You know, when he said that $4 was, quote, the maximum amount to which under the terms of those treaties, end quote, the annuities could be increased. So they all understood this treaty to be basically, in one sense, similar to all the other treaties, in that there was a maximum limit. The obligation was not open-ended. And I think that is, you know, that's not like merely an opinion of mine. I think it's based on, there's no other reasonable way in which you can explain the Crown's actions other than that they assumed this fundamental interpretation of the augmentation clause.
I think on slide 150, you provide some other examples.
Yeah, so again, this understanding of the augmentation clause is further suggested by how the issue of arrears was handled and also interpreted by judges. When in 1877, Meredith asks Ontario to provide specifics on proceeds, he's only expressing an interest in the period where the receipts reach a point that would make it possible to pay the $4 per capita. And then on the next slide, 151, again, examples of this.
This is what we've heard from earlier today.
Yes. I quote from all of these various Crown or judicial actors during this period. There was the Canada Statement of Claim before the Board of Arbitration. There was the 1895 Justice Burbage, who also gave language. He said the treaties, quote, should be construed in a large and liberal way, end quote. But this also, he also reflected the prevailing understanding of the augmentation clause, because for him, it was, quote, a matter of law and right, end quote, that the full amount could not exceed $4 per capita, with any increase beyond that being, quote, a matter of grace, end quote. Hence, the maximum annuity was, quote, equal to a sum that would provide $4 for each Indian of the tribes entitled, end quote. I mean, nobody during this period was talking about any amounts beyond the $4, including the Anishinaabe in their petitions that stimulated or triggered these claims, or the Crown actions on the claims.
And I believe on slide 152, you provide us with an opinion about that.
Yeah, I mean, it's not entirely unsurprising that they had this belief, because they thought that the only unique distinguishing characteristic of the Robinson treaties over either the prior or the subsequent number treaties was that the Indigenous annuitants did not enjoy the full amount of the annuity until after a certain fiscal condition had been met.
And then you conclude this section of your concluding chapter on slide 153.
Can I just go back to your last answer?
Yes,
When you said they had this belief because they thought that the only unique distinguishing characteristic, they being the Crown actors?
yes.
Thank you.
So again, on slide 153, Boron, as I have noted, was a passionate advocate of the Indigenous claims to the augmentations. He pleaded over and over again. He generated considerable correspondence. He made speeches in the House of Commons. He attended Anishinaabe councils. He was involved in this intimately. And he understood the Crown's obligations under the augmentation clause in much the same way as did these other government officials. And that's, of course, reflected in the kind of calculations he did on the arrears subject. You recall all the numbers that he came up with and the solutions he proposed and so forth. Those only make sense if he had this understanding of the augmentation clause that I just described.
Is this an appropriate time for the morning break, Your Honor?
Yes.
This court will recess for 15 minutes. This court will now resume. You may be seated.
Thank you. Before we pick up where we left off, perhaps just a point of housekeeping, Your Honor.
Yes.
At slide 139, the bottom, I'm in chapter 6 now. And in all of slide 140, Dr. Von Gernert testified about the orders in council that each government had passed.
Yes.
Just, to the extent that may be helpful, he provides in this slide, and his testimony, I believe, was that Ontario and Quebec's wording is what's been excerpted here. It's the same. In his report, of course, he also provides the dominions, and you'll find that at,
Sorry, I'm just gonna try and follow you.
I'm
I
sorry,
go to the bottom of slide 139 and it continues into an excerpt on page 140 or slide 140.
yes, just, I'm realizing, and I don't think anything turns on it, but for Your Honor's convenience and just to close it, his report sets out also the Dominions Order in Council at page 401 and 402. So to the extent that Dr. Von Gernert's slide says each government passed orders in council, and then he testified about Ontario's and Quebec specifically, I just note for Your Honor that his report also goes through the Dominions.
Thank you.
And as I said, I don't think anything turns on it, but
I have made a note.
and if I may find my place again. Dr. Von Gernert, before the morning break, we had finished what you've called the thematic concluding remarks about the Crown's understanding of the augmentation clause. The next thematic subheading, if I may call it that, to use, I think, your words, begins on slide 154. It's called Different Routes to Realizing the Augmentation Obligation. I don't believe there's anything in the first two slides, however, that you've not touched on. So perhaps, and indeed, perhaps not 156. But you do provide a conclusion on this topic at 157. Perhaps you could take us through that.
Yeah, so this entire thematic section of my conclusions, as you said, involved my summary of all the different routes of realizing the augmentation obligation. My report deals extensively with all these, different ways in which the obligation could be met, and the different ways in which Crown actors, sometimes transparently and sometimes not so much, understood how the obligation could be met. And in the process, you know, one can only conclude that the process really wasn't simple at all, given the number of different options available, the number of different viable alternatives, and the assumptions held by the Crown actors. These things simply were not simple. I mean, that's the one thing impressed me, but I thought I would be writing a 50-page report, and it turned into this massive compendium. And even then, I couldn't deal with the latter years in as much detail as the earlier years. So the arbitration, as I said earlier today, was still needed as late as 1898 to issue this order respecting the classes of expenditures to be considered. And that in of itself to me is illustrative of the problem. They still hadn't even, you know, there were so many different ways of even that, tackling that issue, that it was still unsettled at the end of the century.
And then you move to a new subheading or thematic, determining when conditions were met. Again, I think we can skip ahead to slide 159. I don't believe 157 and 158. I think you've gone through that in detail this week. You want to, though, describe to us what you say here on 159 about Pardee?
Yeah, so you recall that, you know, Mohat had requested the information so that Ontario could respond to Canada. And then Pardee came up with these, what turned out to be gross figures, and even approximated at that. And he couldn't determine the amount received from the RST. He could not determine the amount from the RHT boundaries, or I should say from the RHT lands, because the boundaries were not defined. And so, you know, there was that issue. But despite all those uncertainties, Ontario and Canada essentially gave the claimants the benefit of the doubt by acknowledging that the Anishinaabe had a just claim to the $4 annuity payable. So it always, you know, it strikes me as I mean, the reason my report is titled the way it is because Blake, despite not having the data, regarded this as a just claim, that they should be getting their $4 in augmentation.
And please remind me, did Blake say for any particular year or as of now?
Immediately.
Right. Immediately and ongoing.
He didn't say ongoing, but as I said, there was this underlying assumption that once you reach a threshold, that it would be in place, because people didn't think of, you know, the lands actually going in a decline, right?
Would you just finish that sentence? There was an underlying assumption that once you reach the threshold,
Yeah, once you reach the threshold, that would continue. Or if you capitalized that there were sufficient sums to pay the $4 into perpetuity, right? If you have capitalization in mind, then of course it's irrelevant whether the proceeds go up or down, then they get it into perpetuity anyway.
I was just going back to Blake's comment that there were just claims. You said, despite not having data, and then you went into an underlying assumption that once you reached it, it would continue. And capitalizing was a way of,
Yes,
on the Crown side, of managing that.
yes,
Do I have that right?
yes.
Okay, thank you.
So Mowat, as I said, he got the party to come up with the approximate figures, and there was still, uncertainty involved, and yet, and as of course, as we find out later, when they actually did more fine-grained analysis, paradoxically, at the very time that both Canada and Ontario agree to augment the annuities, if you did it on a yearly basis, they would not, the Anishinaabe would actually not have been entitled to $4 the year that it was augmented. So they gave them the benefit of the doubt. And once the decision was made in 1875, then, according to their thinking, there was really no need to keep track of future proceeds from the lands for treaty purposes, because when these votes went through Parliament year after year after year, for that 11,000 or 14,000 or whatever it was over the course of the second half of the 19th century, they weren't, questioning this amount. It was just understood that, they're entitled to this full amount. That nobody was standing up and saying, wait a minute, why are we spending this money? We don't even know whether the proceeds are actually contributing enough to meet the augmentation clause. It was just automatic. And so the only issue that really remained was the arrears one. And that's why this whole business of having to track the proceeds came up again. And it then resulted in the 1879 Johnson statements. And then, of course, later in the last decade of the 19th century with the agreement between Ontario and Canada and Quebec that I just alluded to before the break.
And then Dr. Von Burnett, the next several slides, you discuss complicating or the complications that in your opinion made it complicated, or what seemed to make it complicated. I think we've gone through that in detail, but I might ask you to take us through slide 163.
Yeah, so when I'm talking about the determination of when the conditions were met, there again, there are so many different options. And at first blush, it seems like a very simple question, but it's made complex by what might be advantageous or disadvantageous to the parties. So for the Anishinaabe, for example, the main advantage of a year-to-year system was that they would be in receipt of increased annuities the year after the net proceeds from the lands made augmentations possible. So when I say the year after, obviously the record would not be finished until March 31st at the end of the fiscal year. And the first augmentation was generally, for that year, would generally be paid later in the summer. So whatever proceeds there were from the previous year would then go into the following year as a proceed, if you went by year, right? So proceeds for 1856, let's say, would be.
Likely paid in 57.
Exactly, yes. So, so the advantage would, in that system would be that they would get whatever proceeds there were year to year. So payments would be made immediate, but the increases would neither be permanent nor necessarily at $4 per capita.
And when you say proceeds, are you referring there to the augmented amount?
Yes. When we're talking here about the proceeds necessary to augment the pre-augmented annuities to $4. So if you're just talking about a year-to-year system, there is an advantage, obviously, in that the Anishinaabe would get, even if it's a small amount, it would be more than what they may have had the year before. And that's what seems to be understood by Carney when he advised the Garden River Band in 1858 that the augmentation they were entitled to, quote, might be any sum between what they were receiving and $4, but that it was not to exceed $4, right? So under that scenario, you know, they might be getting it instead of $1.50 or $1.60, they might be getting, you know, $2.20 one year, and then maybe the next year they might get $1.80, and the year after that they might get $3, and so that's, I think, what Carney was envisioning. That was his sort of understanding of how it might work, right? Now, at the same time, he was responding to what an assertion that the Anishinaabe had made, where they said they were to receive the 600 pounds per annum for 4 years, and after that, $4 per head. So that scenario is a little different, because in that scenario, setting aside the 4-year time period, you know, what they're saying basically is after a certain time, we're going to get the $4, right? We're going to get $4. That's what we have understood. And so under that kind of scenario, if you, I mean, this is an expectation that the first augmentation would materialize at the maximum amount, and that it would remain that forever after, right? So if you look at that scenario, which is sort of the Anishinaabe version of it, then this could only be financed from a scheme that was accomplished through capitalization.
The Anishinaabes idea?
Yes.
And why is that?
Well, because, you know, you do the math, and if you look at the figures that we have, you're not going to reach $4 on a year-to-year basis until the 1860s. And even then, it's going to go up or down, right? It's not I mean, the best way to accomplish that, if that is the preference, would be to wait until the proceeds accumulate to the point where a capital amount sufficient to pay the $4 from the interest would accrue, right?
I think you've moved over to slide 164 is
Yes. So the fastest route to building a capital fund like that would involve as I said, resisting the modest annuity increases in the few years when they were possible, and instead letting the net proceeds accumulate in a dedicated capital sum until it generated interest sufficient to sustain a permanently augmented annuity at the maximum level. And I noted that this is probably what Russell and Sprague had in mind when they talked about, an annuity fund that was based on, well, Russell referred to a fund as opposed to annual payments. And Sprague definitely had in mind a capitalized annuity fund that would permit the payment of the $4 into perpetuity.
Is there anything else on, you've moved to 164, is there anything else on that slide that you wanted to go through?
Yeah, so the advantage of a scheme that would capitalize would be that Anishinaabe would indeed get the $4 as the first, I should say, their first augmentation would be at the $4 level, and it would be predictable. It would go on into perpetuity, and they would always know that they would expect every year that maximum amount. So that's the advantage for the Anishinaabe. So, I'm just giving you this as an example of, the different routes by which the same conclusion can be reached in terms of meeting the obligation. It all depends on, what you understand to be advantageous. Do you want the small amounts from year to year? Or do you want to let it accumulate until it reaches a point where you get the maximum amount forever? Or is it a combination, right? I mean, there's so many ways you can crunch the numbers, right? So this is
But it is a number crunching
yes,
event.
it is. But decisions have to be made, right? You can't crunch the numbers if the numbers are no longer there because you've already dispersed little
Right.
bits
But those are
along the way.
decisions
Yes,
to be made by the Crown,
exactly.
and they're making them on their own.
They are ultimately, yes, they are making them on their own. I mean, the Anishinaabe, in this particular case, in 1858, is it? They provided
I'm
their
talking about-
expectation.
I was talking about your scenarios. There are different ways to do this.
Yes,
And you're presuming the Crown has different ways to do this. The Crown can decide to capitalize earlier or later.
Yes.
These are your, I'm not sure they come from a historian. These are your views on what they could do to realize the augmentation.
yes, there's two things here. The first is you need to postulate what is possible under, given the circumstances, what is possible.
Yeah.
And then you have to ask yourself, well, what among those possibilities did they actually do? Right. And so for Carney, Carney's view, his solution is a little different from Sprague's solution,
Mhm.
right? So they're adopting two different choices already,
Yes.
right?
Mhm.
So what I'm saying is that when assessing, how the Crown acted in what it did, you have to consider all the different possibilities it had at its disposal from a strictly logical and mathematical standpoint, right? They had, and this is why it's not simple. It's never been a simple matter of reading the augmentation clause, sitting down and, paying it out when it had to be paid out. What I'm emphasizing here is that decisions had to be made along the way as to which of the viable alternatives you prefer. And of course, in the case of Blake and Mowat and Laird's decisions in the 1870s, they could have, picked a solution that was disfavorable to the Anishinaabe interest. But they didn't. They gave them the benefit of the doubt and basically said, look, if they're entitled to $4 by now, let's do it. So, I mean, I think that's my point, if that helps.
We turn then to a thematical subtitle, which I believe is new and that hasn't been covered yet. It's entitled Apparent Deficiencies in Crown Actions. And it's the last theme
Yes.
of the deck. So I would suggest then that we go through these 5 slides in their entirety. Could you take us through the first one at 165, please?
Yeah, so I think I've alluded to what I refer to as deficiencies in these actions over the course of my testimony. And this is just an opportunity to sort of place them in the record all in one place. So the first slide basically just reviews what my conclusions are about the state of affairs in general before we get to the deficiencies. When I look at this record, there is evidence of concerted efforts to meet the Crown's treaty obligation to arrange for the distribution of the pre-augmented annuities. You talked about the Hudson's Bay Company and all the efforts that were made to try and overcome the obstacles. And the record also shows that as of 1875, Crown actors arranged for the payment of the maximum annuities in accordance with their understanding of what that meant under the augmentation clause. It's also noteworthy that Canada and Ontario, through Blake and Mowat, chose not to have the dispute over who should pay disadvantage the Anishinaabe, and that for decades, Canada drew grants from its Consolidated Revenue Fund to pay for the augmentations without, any guarantees that Ontario would ultimately be found liable for the cost. It's also noteworthy that the Anishinaabe were given the benefit of the doubt and the annuities were augmented to the $4 per capita without either jurisdiction actually knowing for certain whether the condition had been met. They did it anyway. I mean, as I said, there are many other alternatives. They chose the benefit of the doubt. And eventually, of course, the SEC as well as the JCPC held that there was no obligation to pay the increased annuities out of the proceeds to begin with. Now, all of that said, that's sort of an anticipation of what comes next. There's always, in history, there's always something that we should legitimately question about these actions. I also uncovered what appear to be inactions on the part of the Crown. And the ones that I referred to here, some I've already alluded to. First of all, the accounting relating to the distribution of the pre-augmented annuities in either their collective or individual manifestations, that is, either the pre-augmented annuity as a total sum, which in the case of the RHT was in the early years placed into their annuity funds, and from there, from time to time, requisitions were drawn. So either in that case, or in the case of the RST, where the amounts were given out on a per capita basis, ended up being very complex. And the amounts varied from year to year. And because the amounts of the annuities varied from year to year, they differed significantly between the RST and RHT territories. And of course, the Anishinaabe between the two territories talk to one another, and they're wondering, you know, what's going on here? Some of us are getting a lot less, some of us are getting more. Well, this led to a state of confusion. And in fact, Carney's evidence suggests that Crown officials did little to assuage these concerns. And so the justifications for the annuity amounts received was poorly communicated to the Anishinaabe.
So is the inaction the poor communication? Because I thought you started talking about the accounting.
Yes, the accounting itself is fine. I mean, I'm not an accountant, but from what I see.
But it's the poor communication. of it.
Yes, because the accounting was so complicated, the Anishinaabe themselves really didn't understand what was going on. And so the Crown
Okay.
did a poor job of communicating to them the justifications, if there were any, as to why the amounts were what they were,
Got it. Thank you.
right? I mean, you know, sometimes it was demographics that was the answer, but none of that was really properly communicated. And so it's only in 1875 that there was a general circular that was sent to all the Indian agents in the field, giving an instruction to properly explain to the band chiefs how, you know, the complex system of capital funds, interest payments, credits, debits, all of that worked, right?
Mhm.
And when I say a circular was sent, it was sent to all Indian agents. It's not just Robinson, is it? To all Indian agents in Canada. And then furthermore, you may recall that in 1870, Canada's Superintendent of Indian Affairs, Plummer, reported that the question of the augmentation clause was, quote, frequently brought before me by the Indians and their friends, end quote, who noted that the promised augmentation had not materialized. And I looked to the record and I couldn't find any follow-up, except that it was forwarded through the usual channels at the upper levels of government between Canada and Ontario. So there's a chain of communication, but I didn't see any follow-up. So clearly, you know, Indian Affairs was made aware by their employee that the question had been frequently brought up. But as far as I could see, there was no action taken at that time. Now, on the-
Slide 167.
Yeah, so, but on the other hand, then we have that 1873 petition from the Fort William band, the RSD band, requesting the augmentation to $4. And that was met with a surprisingly quick response. So we know it was possible. It wasn't always accomplished, but we know it's possible, because in that case, you know, the petition was prepared in the middle of February. It was communicated to the Governor General on April 7th. He only had it a day or two at most. And then it was forwarded to the Deputy Superintendent General of Indian Affairs. That was Sprague.
And you went through this evidence earlier.
Yes.
Okay.
So
Got
that
it.
happened at a very quick pace. But then other responses were not as prompt. So even Sprague's 1873 memorandum acknowledged that the Anishinaabe had from time to time, as he put it, complained that no augmentation had taken place. So Crown officials had contended that the proceeds from the lands were insufficient to allow the augmentation. But what struck me is that I couldn't find any evidence that that kind of accounting of revenues and costs had been communicated to the Anishinaabe in answer to their complaints.
Was there an action? I'm looking at slide 167,
Yes.
and I possibly stopped you when you went through all of the actions, Crown actions in response to that petition. Are any of the actions a communication back with Fort William?
I'm sorry, you're now referring to the bullet 2?
Yes. As I recall in your evidence as well, the story sort of ended with the order in council.
Well, it didn't end with the order in council. It then went to Ontario, and Ontario then through Mowat prepared a legal opinion, which then went to Canada, and Blake prepared the opinion, Laird did the math, and then Oron was advised that the augmentations were going ahead. And so, and then even before the augmentations were paid in 1875, there were already rumors going around. The Indian agents were already reporting that there were, there were rumors that the Anishinaabe population had been aware that they would be getting this $4 augmentation. So they knew in advance already before it was even paid that they were getting it.
Thank
But
you.
if you're asking if there was any formal letter that had been sent to Fort William saying, it's under review or you're going to get paid or whatever, I have no record of that.
Thank you.
Slide 168. We provide an opinion here about the augmentation itself.
Yes. The other thing that strikes me is that the 1875 augmentation of the annuities was more a reaction to an Anishinaabe claim than a proactive decision on the part of the government. And what I mean here is that when I look through the written record, it doesn't suggest to me that Crown actors were proactively advising whether the condition of the augmentation clause had been met, or lay out which of the many options for meeting the obligation was invoked in rendering a decision one way or the other. So even at the time when Mowat and Blake had reached their agreement that there should be an augmentation of the annuities, notwithstanding the disagreement between the two jurisdictions, these officials appeared to admit that Crown action was overdue. It's just that, when you read the wording of their communications, it's like, yeah, I mean, if they're due now, then, as I said in my earlier testimony, there was always a lingering suspicion, if not an assumption, that the augmentations were already payable prior to 1874. And even the conclusion that the Anishinaabe claims were justified was not based on a detailed accounting, but rather on estimates offered by Pardee and then guesses by Mowat. So, I mean, in hindsight, you know, you would think that Pardee would have provided not just the gross. Well, it's easy to say now. Pardee really should have done what Johnson did in 1879 instead of the little guess about how much before and after Confederation the RSD had in proceeds, right? The fine-grained analysis is what's really required. So, but he didn't. So, you know, that, to me, that's another, you know, an example of an inaction. And he didn't even, you know.
What do you say is the inaction, the failure to do the accounting?
Yeah, when he's asked by Mowat to.
Well, not when, but generally, this is apparent deficiencies in Crown action. So
Yes,
they don't communicate,
yes,
but are you all saying you said they appear to admit that their actions are overdue, but they finally make a decision, it's not based on detailed accounting,
yes.
but based on estimates by Pardee, guesses by Mowat. So do you say, are you concluding that that's a failure, that they don't do the accounting?
What I'm suggesting as a failure is when you look at the fine-grained analysis in 1879, that did not happen in 1873 by the same department.
That did not happen,
That did not happen.
as opposed to they didn't do it. That's what I was asking you.
It's the same difference. It did not happen because they did not do it. Right.
Got it.
Does that take us to your last slide, 169?
Okay, so as I said, the first detailed accounting that we have on record was in 1879. And that was prepared as a response to the question of whether arrears were payable rather than a proactive decision to keep such a record. So again, it's kind of a reactive accounting. It was done at the request of Canada that Ontario provide the prerequisite information. Now, in fairness, it took some time, in part because Ontario didn't have the particulars on the boundaries of the RHT. But after Canada was made aware of that, Canada very quickly provided Ontario with at least an approximation. And what also struck me, Your Honor, was that, you know, this was only done in 1877. You know, the treaty is 1850. The inadequacies of Robinson's definition of the metes and bounds of the RHT are already in place in the treaty. The treaty language is always there. So it's not as if they just suddenly discovered that, you know, this is a difficulty. The treaty language is always there. But nobody really addressed this issue of where that boundary was, which was the real holdup in this process, until 1877. And to me, that's a little puzzling.
Sorry, just for clarity, that boundary is referring to what boundary?
The Robinson-Huron Treaty boundary, more specifically, the eastern boundary. which is not delimited in the Robinson Treaty in a manner that is rendered, that can be rendered on a map without recourse to additional evidence.
We're talking the Ottawa Valley issue.
Yes.
Okay.
Whether or not to include the Ottawa Valley. And to this day, that's an issue. You look at various modern maps of the Robinson Huron Treaty boundaries.
It's okay. We don't need to get into it. You're identifying forest deficiencies.
Yes.
And is one of them not addressing the boundary issue or not doing the accounting?
One of them is that the boundary issue. I mean, Canada should have provided an earlier analysis of where that boundary is, rather than a reaction to Ontario's request in 1877.
Thank you.
And then after that boundary issue was resolved, at least, an estimate was given. But once, it was rather arbitrary, but once that was resolved, it took another 2 years for Johnson to present the details of the annual revenues and expenditures. And my point here is that it would not have taken 2 years had that specific information been prepared on a regular basis and inserted into the annual reports of the Crown Lands Department. Because one of the reasons it took 2 years is it's a rather arduous process to try and reconstruct it after the fact.
I think you're talking to the converted on that point.
I'm just summarizing my report.
Just to say that you can assume that everyone here understands that it's a rather arduous process to go back a number of years.
Yes, I understand that economists have been retained to, deal with this at great length. So I'm not surprised, or we should not be surprised that it would be difficult back in the 1870s when nobody had computers and databases and so forth.
Thank you, Dr. Von Gernert. That takes us to the conclusion of your slides and your demonstrative. And really the questions I have for you about what we've been calling the Crown Conduct Just Demands Report. I do have 2 further questions on agreement with my friend, Mr. Schachter, that I'd like to ask you. The first, who authored this slide deck?
I authored the slide deck. I worked on it the entire week before my testimony.
Thank you. And the second is it your belief that in preparing it, that you have used and you are consistent with the findings and documents and opinions that you express in your Just Demands report?
Yes, as far as I know, they are consistent. I tried as much as possible to provide the page numbers where I deal with these subjects. I mean, in every presentation, when you're trying to summarize hundreds of pages, you may not use precisely the same words because you're summarizing, but it's the slide deck should be consistent with the report that I wrote, and if there are any occasions where it's not, I'm sure they'll be pointed out to me.
Thank you, Dr. Von Gernet. That does conclude my examination in chief of this witness on this particular report. My colleague does intend to take over, but I wonder now if, with agreement of my friend, we might mark the demonstrative now as a numbered exhibit rather than a lettered one for identification.
Yes, with those two questions being answered, it can be marked as a numbered exhibit, and I will indeed deal with it at any variances in cross-examination.
Thank you very much. And what number are we at?
That's 52.
Thank you. Okay.
Good afternoon, Your Honor.
Good afternoon, sir.
Good afternoon, Dr. Von Gernet.
Good afternoon.
Your Honor, we are turning to Dr. Von Gernet's second report, which has been marked as Exhibit 5050,
Yes.
and it's titled Anishinaabe Principles, Perspectives, Understandings, and Expectations in Relation to Sharing under the Robinson Treaties of 1850. It's a volume, I believe, in buff cover.
And we have been referring to it as the Perspectives Report.
That's right, Your Honor, and I'll continue to do that.
Thank you.
The other material for this section of the examination, Your Honor, is a demonstrative slide deck with
you.
coil volumes. That's correct, yes.
Thank you very much.
And Dr. Von Gernet, do you have the coil volume in front of you titled Anishinaabe Principles, Perspectives, Understandings, and Expectations in Relation to Sharing under the Robinson Treaties of 1850?
I do.
So Dr. Von Gernet, maybe we can start by you telling us what this coiled volume is and whether you prepared it.
Yes, this is, I did a similar presentation as I did for the other report. And so I should say from the outset, it was not originally my idea to provide PowerPoint slides. I've done so in previous cases, but not for probably a decade. So the idea of providing demonstrative through a slide deck was not mine, but was suggested by counsel. I undertook to sort of summarize what are my major points in my report of October 2022. And this is the result, this particular slide deck. So I'm hoping it'll be of some assistance.
Thank you, Dr. Von Gernet. Your Honor, our intention is to have this demonstrative deck marked as a numbered exhibit. We can, if it's the preference of my friend, mark it as the next lettered exhibit and then revisit this at the end of the examination in chief. I see my friends on the seat.
Yeah, I don't think, if the witness has said that he authored it and that he understands it to reflect what's in his report, that's all I need. Have it marked as an exhibit, and any discrepancies I'll deal with.
Let's do it now then.
All right, thank you.
Exhibit 53.
Congrats, John.
Thank you.
Thank you, Your Honor. Dr. Von Gurnett, could we turn to slide 2 of your slide deck, Exhibit 53, please? And this is where you discuss the assumptions for your perspectives report. And I wonder whether you could please describe for the court your understanding of your mandate.
So what I did here is just simply reiterate what I say on page 3 of my report, and that is an excerpt from my letter of instruction, which was included in the appendix to my report. And so as I understood and still understand my mandate in this regard, I include these excerpts. So the first, so these are the words of counsel in the letter of instruction. The Court of Appeal, particularly in and around paragraphs 320 to 325 of its decision, has addressed the issue of sharing of NCRRS, which I assume to be net crown resource-based revenues, and the potential role of Anishinaabe principles and perspectives in relation to that sharing, end quote. Quote, the plaintiffs have provided expert reports which address Anishinaabe understandings and expectations in relation to sharing under the treaties, as well as the principles and practices the Anishinaabe might have understood to apply in the implementation of the treaties, including their annuity augmentation provisions. In respect of this issue, we ask that you review the reports of Dr. Heidi Bohacker and Dr. Heidi Stark, served on behalf of the RHD plaintiffs, and 2 reports of Dr. Paul Dribbin, served on behalf of the RST plaintiffs, and identify areas of agreement or disagreement. We also ask that you opine on any other matters you consider appropriate arising from the Court of Appeal decision. So those are my instructions.
Thank you, Dr. Von Gurnett. In reading that, you indicated references to Dr. Heidi Boaker and Dr. Heidi Stark. And just to confirm, you understand that the parts of your perspectives report, which addressed the reports of Drs. Boaker and Stark, have been redacted from Exhibit 50, correct?
Yes, that's my understanding.
Thank you. Now, if we can turn to slide 3, Dr. Von Gurnett. And here you talk about the role of assumptions in your perspectives report. And I wonder whether you could take the court through the role of assumptions.
Yeah, so this is the kind of this is the kind of case where assumptions are particularly important. The task assigned to the experts who wrote the opinions, which my own report is responsive to, is contingent on the assumption or assumptions held about how the augmentation clause was understood by the parties to the treaty. Now, from, as an independent expert and ethno-historian, a proper scholarly inquiry into the potential role of Anishinaabe principles and perspectives, understandings, expectations in relation to sharing under the treaty requires an analysis of the underlying assumptions. And the one thing that we always teach in university is that if you're going to be a critical thinker, you must always be attentive to the assumptions. Without doing that, you run the risk of you run the risk of having the assumptions themselves lead to conclusions. And so, and you need to know that depending on the assumption you pick, an inference or opinion will vary. So, and in some instances, an assumption that's held by a researcher is so crucial and so inextricably part of the task that it has the effect of becoming the researcher's conclusion. And this only leads to what we refer to as the logical fallacy of circular reasoning. And it also leads to other methodological deficiencies, but the main one is circular reasoning. We often encounter this in ethnohistory or in anthropology in general. And it's something that I began exploring when I was first trained as an archaeologist, because there it becomes even more manifest how assumptions become conclusions. So to give force to this point by way of a concrete example, I've used and compared and contrasted two different assumptions about how the augmentation clause was understood by the parties to the treaty. And then I assessed how these assumptions impact answering questions about Anishinaabe principles, perspectives, understandings, and expectations in relation to sharing. The terms principles, perspectives, understandings, and expectations, those are the words that are used by the experts that I'm responding to. So I'm not, those are not my words. Those are the actual words that are being used. So.
Thank you, Dr. Bungani. You mentioned a concrete example, so perhaps we could turn to slide 4.
Yes.
Where you talk about contrasting assumptions, which you discuss in your perspectives report.
Yes.
And could we go through that for the court and tell us about how those contrasting assumptions factored into your methodology as an ethnohistorian?
Yeah, so if we contrast two different assumptions, the first one is derived from my own independent reconstruction of the historical context of the Robinson treaties. And as reflected in my other expert opinions. And, I appreciate that, there are legal conclusions that would be made using the same assumptions and so forth. Well, my point is not to challenge those in any way. All I'm doing here is I'm pointing to an assumption that is derived from the historical record that I looked at in my perspectives report. That is, it's the assumption that I earlier today referred to in relation to the augmentation clause that Crown actors held for a quarter of a century or for half a century. And hence it becomes, whether or not it's a legally valid assumption is not my concern, but it is historically a valid and viable assumption because it was actually held by Crown actors over the course of that period. And so to me, it's just if I'm going to make the point, it is a viable one. It's not merely an opinion of mine. It's a viable historical assumption to make because it was actually held by people. And I can demonstrate, and I think I did demonstrate that it was held by actual people in the past. So in setting, and then the second assumption is drawn from the findings of the Court of Appeal. And I wanted to emphasize, Your Honor, even though I may not have emphasized this adequately enough in my report itself, that in setting out my approach in this way, I'm not challenging legal findings of this court or of the Court of Appeal. However, I am compelled by the standards of my own profession to entertain assumption one as a viable alternative, only to make a point, a methodological point. And in fact, it would have been all but impossible for me to provide a fair and objective reconstruction of 19th century Crown conduct in relation to the annuity payment obligations under the treaties and the understandings of officials which underlay their actions, as I just did in their just demand report, had I been obliged to accept a priori that there's only one proper interpretation of the annuity augmentation clause and that this matter has been settled, I would not have been able to write the entire Crown conduct report. So I just say that because, you know, I'm not here to in any way question legal findings. All I'm doing here is pointing to what happens if we change the assumptions. And once we realize what happens when you change the assumptions, you then realize that in the case of Dr. Driven, the assumptions more or less inevitably lead to the conclusions. So the best way to illustrate that is just to change the assumption and see what happens, right? So this is a methodological thing that, and it's a very important point because, you know, it becomes very difficult for me to respond to something like Dr. Driven's report, especially in this context, because we're in a very unusual situation where there's already been a phase one in a trial in which the same experts have testified for these various parties. I've never encountered this sort of thing before, so and it's placed me in a particular bind because, you know, I get pressure to concede a judicial decision, but I cannot let a modern opinion of a court of appeal interfere with my ethno-historical reconstruction, because that counters my professional obligation to avoid presentisms. So what we have in essentially, I mean, it's not a big deal because I deal with assumption two, obviously, as well, and I talk about the concerns I have about Dr. Driven's approach to this.
Can I just see if I've got this right? You get pressured to concede a judicial decision, but you cannot let a modern opinion of a court of appeal interfere with your professional reconstruction of events.
Yeah, so I mean, there are always discrepancies or distinctions to be made between what courts decide and what ethnohistorians conclude. Entire books have been written, for example, about the difference between an historical and a legal interpretation of the treaty that was the subject to the Supreme Court of Canada case in Seaweed. There's whole books on that, where historians have a whole different understanding of what that agreement was, and the Supreme Court of Canada has opined on it and rendered a legally binding decision on it, right? So these kinds of differences are not unusual. Right, but let's say that I had approached my Crown conduct report with an a priori assumption that there's only one way in which the augmentation clause could be understood. None of these Crown actors' actions would have been sensible to me, right? Because they're not in accord with that. They're in accord with a different assumption,
Right.
right? So
So there's a different assumption.
exactly. And that different assumption, whether it's right or wrong from a modern legal vantage, is a viable historical assumption because it's held by actors at the time. And it's demonstrably held. It's not my interpretation of their assumption. This is the only assumption they could have had in making the decisions that they did. Right.
Thank you, Dr. Von Garnet. Your Honor, I see it's slightly after 1 o'clock. If this would be a convenient point for the court, we could take the lunch break.
Thank you. How does it,
2 o'clock is fine for us, Your Honor, if that's enough time.
does it work for everyone? Does 2 o'clock work?
Yes, that's fine. I was actually wondering.
Are you getting along with Mr. Rankin? How are you, what does a 2 o'clock start and a 4 o'clock finish look like?
Your Honor, I
that-
think if we're back at 2 o'clock, we should be able to get through today, but we did have a conversation this morning about this, where if we need to bump into Monday, it should be fine with the overall schedule.
Okay. And I'd like you to continue to, let's end at 4 so you can get your planes. And I'd like you to continue to think that you take the time you need.
Thank you, Your Honor.
All right, we'll work that out.
This court will recess until 2 p.m.